1. Mr. Speaker, ladies and gentlemen, in the 1960s, Brady was sentenced to death after being convicted for murder. However, his sentence was retroactively reduced to life imprisonment because it was found out that the prosecutor withheld evidence. That in and of itself is a huge impact and harm that can lead to many defendants, even if they're guilty, getting overpunished by the law, and in the worst cases, death, ladies and gentlemen. On side proposition, the state prosecutor, who we characterized and told you has every means, motivation, and capacity because of their network, because of their resources, to ultimately use their clout and their influence as a socio-legal battering ram to bend the arc of justice towards the ends that they want, is ultimately a disgrace. These state prosecutors, because you allow them on side proposition, become judge, jury, and executioner at the point in which they undermine the criminal justice system and impede the due process that they took the oath and stood before the bar to be able to withhold. We won this debate by a clear margin from first opposition because we were able to differentiate the difference between prosecution and a civil case. The fact that this is not an actor motion for that state prosecutor of what they do, and this is a value judgment debate about a neutral observer looking at the legal system and looking at the criminal justice system, is quite important. We explained a few things that they had little to no response to. Number 1, we framed a principled push on the nature of obligation, something that Matthew and Winkle were able to talk about, given that these people are state prosecutors. And if they're as perverse as the other side might say, then that's every call to action for them to be able to uphold that obligation of having a fair trial. A speedy one can potentially lead to people like Brady and people who are minorities and persons of color getting significantly wrecked. Number 2, we talked about the core presupposition of how the investigative process works. Because it's not like they're gonna willy-nilly spam evidence and all of these things. All of these things that they have an obligation to forward are going to be scrutinized by the particular judges, and there's still going to be a trial to discuss those things even if it takes longer. Number 3, we talked about an urgency to be able to forward evidence as a tipping point to be able to potentially reduce severe kinds of instances where these people are overcharged for something even if they did commit it. But imagine, what if they didn't do it and that smoking gun was fabricated, or that smoking gun had another kind of evidence to explain it? We potentially save lives. Their side told us a few assertions, right? Number 1, oh, it takes long. Number 2, you can do plea bargains. Number 3, there are modern day developments and stuff. Number 4, prosecution bad. All of things which Matthew and I, in the top of our speeches, were able to respond to, and Winkle, in their particular whip speech, were able to position and outweigh versus the positive and negative material given in the round. In fact, we think that in instances like Brady, where you potentially take that plea bargain and are led to death, ladies and gentlemen, only to retroactively be rolling in the grave because these things could significantly be prevented, is exactly what motivates our side of the house. Ladies and gentlemen, we're not here for a fast trial. We're here for a fair and accurate one. And in order to be able to really be charitable, we need to be able to see the full picture. They have the obligation, very proud to stand on side negative.